The details of these new bills include that for certain retail employers, they will now be prohibited from utilizing on-call scheduling. They will have to post the schedules at least 72 hours in advance and will not be able to make changes, absent a few exceptions, within 72 hours of the start of the shift. In addition, another provision for retail employers is that employees will have to work at least 20 hours in a 14-day period. With respect to certain fast food employers, they will have to come up with the schedule at least 2 weeks in advance, and there will be certain penalties that will be incurred if they don't do so. They will now also have to provide new shifts first to existing employees before they can go out and hire new employees. This will help employees get potentially from a part-time schedule to a full-time schedule. There must also be, among other provisions in the bill, at least an 11-hour break for certain fast food employers between shifts. These new laws will have a significant impact on employers that are covered in both the retail industry as well as the fast food industry. First of all, they will add expenses to the bottom line, not just in terms of increased wage costs, but potentially increased benefit costs, because as a result of these laws, you may have more benefit-eligible employees. This trend with respect to this legislation should continue. This is a very hot topic. New York follows both San Francisco and Seattle in coming up with legislation addressing this area. In addition, several states have pending legislation dealing with schedule predictability. I think also that these laws reinforce the fact of what we have been seeing, which is we are going to see more aggressive legislation affecting workers' rights at the city level and to some extent at the state level to counter the more lax regulatory and enforcement environment at the federal level since the transition to the Trump administration.